Good day. I'm Dr. Martha Bradley. Welcome to your lecture on the formal requirements for treaty conclusion. The purpose of this lecture is to explore the formal requirements necessitated by the law of treaties as codified in the Vienna Convention on the Law of Treaties, or in short, the VCLT. It is important when you refer to this treaty that you state Vienna Convention on the Law of Treaties, or VCLT, and not only Vienna Convention, as there are several other treaties that were in fact signed in Vienna. For example, the Vienna Convention on diplomatic relations and so forth. So please be specific when you refer to this instrument to state the Vienna Convention on the Law of Treaties, or in short, the VCLT. At the outset, I wish to answer the question of how a state expresses its consent to be bound to a treaty. Article 11 of the VCLT provides for specific means by which a state can express its will to be bound by a treaty. This list includes signature, the exchange of instruments constituting a treaty, ratification, acceptance, approval or accession, or by any other means if so agreed. So, a state can be formally bound if it is through signature, the exchange of instruments constituting a treaty, ratification, acceptance, approval or accession, or by any other means if so agreed. Remember, international law is consent-based, so states can agree to a different method. The first objective of this lecture is that you need to be able to identify who is authorized to sign a treaty under Article 7 of the VCLT, and it's of key importance as an international lawyer to know the exact provision as authority. So, Article 7 of the VCLT, those who may express the state's willingness to be bound to a treaty, is codified there. So you will need to be able to, on a factual basis, determine whether a treaty is valid based on the person or category of persons who signed a treaty. The second objective of this lecture concerns the step a state needs to take after signature. So first, the first objective is to determine who can sign a treaty on the state's behalf. The second is, what is the next step after signature? This step concerns the registration of a treaty as provided for in Article 80 of the VCLT and Article 102 of the UN Charter. The third objective of the lecture is to clarify when a treaty enters into force. When a treaty enters into force. And then finally, I will illustrate through a case study of Somalia versus Kenya, a case which appeared before the International Court of Justice, how the formal requirements for treaty conclusion have in practice been assessed by the International Court of Justice. I now turn to our first research objective, which essentially concerns the question of who can sign a treaty. I must point out that the formal requirements for treaty conclusion in this lecture concerns written treaties only, as defined in Article 2 of the Vienna Convention. You will recall that essentially, a treaty is defined in Article 2A of the VCLT as an international agreement concluded between states in written form and governed by international law. The answer as to who can sign a treaty on behalf of a state is provided for in Article 7 of the VCLT. I would like to mention that this is a closed list. If a representative of the state does not meet the requirements set out in Article 7.2 or does not fall under the specific categories of persons set out in Article 7 of the VCLT, then such a person cannot bind the state. So, first, we look at Article 7.1 and then at Article 7.2. These provisions explains who and in what circumstances can sign a treaty on behalf of a state. So if the person is not qualified under Article 7.1, fulfilling those requirements, or category of persons under 7.2, then the signature will be invalid and that state will not be bound by that specific treaty. I now turn to Article 7 of the VCLT, and you can read the text with me as it will appear on the screen. Article 7 VCLT, full powers. Article 7.1. A person is considered as representing a state for the purpose of adopting or authenticating the text of a treaty, or for the purpose of expressing the consent of the state to be bound by a treaty if, Article 7.1a, he produces appropriate full powers, or Article 7.1b, it appears from the practice of the states concerned, that means those states that's entering into the treaty, or from other circumstances that their intention, of course this refers to the intention of the states, was to consider that person as representing the state for such purposes and to dispense with full powers. So you will see that Article 7.1, as you look at the text, concerns not specific categories of persons, but persons that falls outside the scope of Article 7.2, right? And such persons has to produce either full powers, or you have to be able to show that, in fact, it was intended by the parties to the treaty that they could also sign the treaty. I now turn to Article 7.2 that appears on your screen. In virtue of their functions, and without having to produce full powers, the following are considered as representing their state. So these categories do not need to produce full powers. Article 7.2a, heads of state, heads of government, and ministers for foreign affairs for the purpose of performing all acts relating to the conclusion of a treaty. Article 7.2b, heads of diplomatic missions for the purpose of adopting the text of a treaty between the accrediting state and the state to which they are accredited. Then Article 7.2c, representatives accredited by states to an international conference or to an international organization or one of its organs for the purpose of adopting the text of a treaty in that conference, organization, or organ. So, in order to answer the question of who can sign a treaty on behalf of a state, I would like to divide Article 7 of the VCLT into two parts. Article 7.1 of the VCLT concerns persons that have to provide full powers as they are not listed in the closed list of Article 7.2 of the VCLT, which allows for certain specific categories of persons to be able to sign treaties owing to their functions, or simply put, their job, without having to produce full powers. Thus, we have persons who can sign treaties owing to their specific position as per Article 7.2 of the VCLT, and then we have certain requirements demanded from individuals who are not listed in Article 7.2, but who can still sign a treaty on behalf of their state only if they comply with the requirements set out in Article 7.1 of the VCLT. And that is why it's important for international lawyers to know these provisions and subparts off by heart so that they can employ them. So, let's first turn to the designated persons who may bind a state without having to produce full powers, as per Article 7.2 of the VCLT. Basically, there are three categories of designated person. The first category concerns those individuals traditionally tasked with concluding treaties on behalf of a state. These are head of states, for example, President Ramaphosa, heads of government, where a state has a government system, for instance, in the United Kingdom, in which case it would be the Prime Minister, Boris Johnson, and finally, the Minister of Foreign Affairs. When a head of state a head of government or a minister of foreign affairs signs a treaty, they need not produce full powers, as it is customary law that as part of their official role, they are able to conclude treaties, and this indeed is codified in Article 7 to 8 of the VCLT. The second category of persons who may sign treaties are heads of diplomatic missions. These diplomats, who are heads of their missions, may sign a treaty on behalf of the accrediting state or the sending state and the accrediting state to which the diplomat is accredited. So I will give an example to simplify. The United States ambassador, who is head of mission in Pretoria, may sign treaties on behalf of the USA between itself and South Africa. The third category of persons who may sign treaties on behalf of their state are those representatives of a state that are accredited by the state to an international conference or to an international organization of one of its organs for the explicit purpose of adopting the text of a treaty in that conference or organization or organ. For example, the Paris Agreement on Climate Change was signed on behalf of South Africa by the Minister of Environmental Affairs, at the time, Mrs. Edna Molewa, on 11 April 2016 in New York. The Minister of Environmental Affairs represented South Africa in New York for this occasion specifically. She therefore did not need to produce full powers, as she fell under the category of persons permitted to sign treaties on behalf of their states in accordance with Article 7.2 of the VCLT. I now turn to the criteria required for individuals not listed in the categories of persons who may sign treaties as set out in Article 7.2 of the VCLT. Article 7.1 of the VCLT provides that a person is considered to represent a state for the purposes of signing a treaty if such a person can produce the appropriate full powers, either from the practice of the states concerned or from other circumstances, to the effect that it was the intention of the state to consider that person as representing the state for such purposes and to be dispensed with full powers. As per Article 2C of the VCLT, as per Article 7.2 of the VCLT, which defines full powers, I want to reiterate, Article 2C of the VCLT, full powers means a document emanating from the competent authority of a state designating a person or persons to represent the state for the purposes of negotiating, adopting, or authenticating the text of a treaty, for expressing the consent of the state to be bound by a treaty, or for accomplishing any other act with respect to a treaty. So if you are unsure about the meaning of what it means to produce full powers, you can go to Article 2C of the VCLT, which is the definition clause, and read this provision that I have just cited. Then, now that you are informed about Article 7's contents and Article 2's contents, you need to be able, as an international lawyer, to identify from a set of facts, because this is what you will do in real life, whether a person or category of persons can legally enter into a treaty on behalf of a state. Let's explore some examples. The United States of America, China, Russia, and France signed a treaty known as the SAFE 2020 Treaty on 20 May 2020. Of course, this is fictional, concerning the development and distribution of a new COVID-19 vaccine called Putin X. Russia agrees to share the formula of Putin X with the member states of the SAFE 2020 Treaty, as such states will build laboratories in order to develop and bottle Putin X. The heads of states of the respected countries signed the SAFE 2020 Treaty on behalf of their states, except in the case of the USA. Ivanka Trump, at the time, the first daughter of the USA, presents full powers at the SAFE 2020 signing ceremony and signs the SAFE 2020 Treaty on behalf of the USA. So I pose the question, is this treaty valid? Could Ivanka Trump, who at the time was the first daughter of the United States, sign the SAFE 2020 treaty on behalf of the USA? The answer is yes. Why? As she is not president or foreign minister, she is not included in the list in Article 7.2. The answer lies in Article 7.1 of the VCLT. Ivanka produced full powers and therefore his signature is valid and the USA is bound. Would the situation be different if Ivanka did not produce full powers? Indeed, then she would not have had the legal authority to sign the treaty, and the USA would not have been a part of the SAFE 2020 treaty. In the next example, I would like to carefully look at a multiple choice question and identify the category of persons that may not sign a treaty on behalf of the state. The question will now appear on the screen. Article 7 of the Vienna Convention permits certain categories of people to sign treaties on behalf of a state. Identify which of the following groups of individuals may not sign a treaty on behalf of the state. Option A, an individual who can produce full powers in accordance with Article 7.1a of the Vienna Convention on the Law of Treaties. Option B, the head of the opposition party of the state in the event that the foreign governments recognize the head of the opposition party as the legitimate leader of the state. Option C, the head of a diplomatic mission for purposes of adopting the text of a treaty between the accrediting state and the state to which they are accredited. Option D, representatives accredited by states to an international conference for the purpose of adopting a treaty at that conference. Let's go through each of the examples to determine its legality under Article 7. Option A. Indeed, an individual who can produce full powers under Article 7.1 of the VCLT can bind a state. That is correct. Let's now turn to option B. The head of the opposition party cannot bind the state. First, he does not fall under the categories of persons listed in Article 7.2a of the VCLT who may bind a state without producing full powers. Secondly, the opposition leader does not comply with the requirements listed in Article 7.1 as he does not have full powers to produce as evidence that he can bind the state. And there certainly is no state practice to support the ability of an opposition party to bind a state. Options C and D are valid, as these categories of persons, the head of diplomatic mission for the purpose of adopting the text of a treaty between the accrediting state and the state to which they are accredited, and representatives accredited by states to an international conference for the purpose of adopting a treaty at that conference, are provided for as categories of persons that may sign a treaty on behalf of the state without having to produce full powers as codified in Articles 7.2b and 7.2c of the VCLT. Now that the treaty has been signed, the second objective of this lecture concerns the next step, where the question is raised as to what the state has to do after signature to satisfy the formal requirements for entering into a treaty. After signature, every treaty entered into by states must be registered or transmitted to the Secretariat of the United Nations. This is determined by both Article 80 of the VCLT and also by Article 102 of the Charter of the United Nations. Article 80 of the United Nations Charter reads as follows. Article 80, Registration and Publication of Treaties, Article 81. Treaties shall, after the entry into force, be transmitted to the Secretariat of the United Nations for registration or filing and recording, as the case may be, and for publication. Of course, this refers to publication in the United Nations Treaty Series. Then, Article 82. The designation of a depository shall constitute authorization for it to perform the acts specified in the preceding paragraph. So the most important part for our purposes is Article 81, which states that after entry into force, a state must register such treaty with the UN Secretariat. Article 102 of the UN Charter similarly determines. Article 102.1. Every treaty and every international agreement entered to by any member of the United Nations, and this is all states, all recognized states are members to the UN, of the present charter comes into force, shall as soon as possible be registered with the Secretariat and published by it. So the United Nations came into force in 1945, which means that all states in the world has to register their treaties with the Secretariat. Then, Article 102.2 of the UN Charter. No party to any such treaty or international agreement which has not been registered in accordance with the provisions of paragraph 1 of this article may invoke that treaty or agreement before any organ of the United Nations. This is important because it describes the legal consequences of non-compliance with Article 102.1. So, the legal consequences of not registering a treaty with the Secretariat of the United Nations is that such a treaty may never be invoked before any organ of the United Nations, with the result that if a dispute arises where a treaty has not been registered with the Secretariat of the United Nations, the dispute will not be heard by the International Court of Justice. So then the disputing state will not have a legal leg to stand on under international law before the International Court of Justice. Why? Because they did not register the treaty. The third question that I would like to raise is when a treaty enters into force. I answer this question through a fictional example. President Ramaphosa signed a bilateral treaty with Namibia on 17 July 2021 called the Ventilator Relief Treaty, in terms of which South Africa agrees to provide Namibia with vaccine support in exchange for ICU beds and ventilators reserved in hospitals in Windhoek when South African hospitals are at full capacity during the COVID-19 pandemic. This treaty has been registered at the Secretariat of the United Nations. You are the Chief State Legal Advisor, and President Ramaphosa asked you when this treaty comes into force as South Africa prepares for a possible next wave of the pandemic. The answer to this question lies in the relevant treaty itself. You must consult the text of the specific treaty. Thus, look at the administrative clauses at the end of the Ventilator Relief Treaty. As this is a bilateral treaty, the treaty will determine the date on which it enters into force. Regarding the entry into force of multilateral treaties, the treaty itself will either state that the treaty will come into force after a minimum number of states have ratified the treaty or on a specific date. That is the case for multilateral treaties. I offer Article 126 of the Rome Statute of the International Criminal Court as an example of a multilateral treaty coming into force at a set time frame. Article 126 of the Rome Statute entry into force, subsection 1. This statute shall enter into force on the first day of a month after the 60th day following the date of the deposit of the 60th instrument of ratification. This means after 60 states ratified, accepted approval or accession with the Secretary General of the United Nations. Therefore, in terms of Article 126 of the Rome Statute, only after 60 states has ratified or signed the treaty, then after a time period it will go into force. And that indeed happened very swiftly. Another example, the protocol of the Statute of the African Court of Justice and Human Rights, this is a regional African treaty, serves as an example of where the treaty comes into force only once a certain number of states have ratified it. Article 9 of the Protocol of the Statute of the African Court of Justice and Human Rights entry into force reads as follows. The present protocol and the statute annexed to it shall enter into force 30 days after the deposit of the instruments of ratification by 15 member states. To date, this specific treaty has not entered into force as its required number of member states have not ratified it. We are now at the final substantive part of our lecture, which concerns a case study of Somalia versus Kenya, 2017, before the International Court of Justice. So I offered the facts of the case first to create context. A dispute arose between Somalia and Kenya over the outer limits of the continental shelf, thus a dispute concerned with maritime boundaries. Both Kenya and Somalia are parties to the United Nations Convention on the Law of the Sea, UNCLOS in short. Under Article 76(8) of UNCLOS, a state party to this convention intends to establish the outer limits of its continental shelf beyond 200 nautical miles, must submit information on such limits to the Commission on the Limits of the Continental Shelf. On 7 April 2009, the Kenyan Minister of Foreign Affairs and the Somali Minister, listen carefully, for National Planning and International Cooperation signed a document titled Memorandum of Understanding between the Government of Kenya and the Transitional Federal Government of the Somali Republic in order to grant each other no objection in respect of the submission to the Commission on the Limits of the Continental Shelf on the outer limits of the continental shelves beyond 200 nautical miles in accordance with UNCLOS. So essentially, Somalia and Kenya signed this MOU, that was the name of the document, in which it agreed not to object to the other state submissions to be made under Article 768 of UNCLOS. After a passage of time, Somalia challenged the validity of the MOU and alleged that this did not constitute a treaty, this document. Kenya, on the other hand, argued that the MOU did constitute a treaty and that consequently it was duly registered under Article 102 of the UN Charter. The relevant legal question is whether the MOU constituted a treaty or not. I turn to the information on the MOU itself. Even though the document is called an MOU, we need to assess whether it fulfills the requirement of a treaty as stipulated in Article 2 of the Vienna Convention on the Law of Treaties. You will recall that the elements of a treaty is, for purposes of the VCLT, is a written agreement between states regulated by international law, which creates a legal obligation. This MOU indeed was in writing. The MOU was regulated by the legal relationship between the states in terms of maritime delimitation between Kenya and Somalia. The MOU did indeed create a legal obligation between these two states to grant no objection to each other's submissions on the outer limits of the continental shelf beyond 200 nautical miles. So there was a legal obligation. Finally, the document referred to the requirement under Article 768 of UNCLOS as the reason for the MOU. So this document indeed is regulated by international law of the sea. Apart from the document fulfilling the requirements of a treaty, it was also signed. So, first we see that this MOU was indeed signed on 7 April by the Kenyan Minister of Foreign Affairs and the Somali Minister of National Planning and International Cooperation. Thus, I asked the question, as the court did, if these signatures are valid. Or in other words, could these respective ministers enter into a treaty on behalf of their states? Owing to this capacity, or his capacity as foreign minister, the Kenyan Minister of Foreign Affairs fall under Article 72A of the VCLT and therefore can bind Kenya owing to his position and not needing to produce full powers because he's a Minister of Foreign Affairs, straightforward. You might notice the peculiar title of the Somali minister, which is Minister of National Planning and International Cooperation. The facts of the case show that the Somalian minister, in fact, produced full powers prior to signing the MOU, in fact, the treaty as we've established, as required by Article 71A of the VCLT. Therefore, both ministers could bind their states by signing this treaty. We have now established that the document constitutes a treaty and that the ministers were authorized to bind the states to the treaty through signature. The nature of the agreement that this is a treaty is also confirmed by the fact that in June 2009, this MOU or treaty, which is a bilateral treaty, was submitted by Kenya to the Secretariat of the United Nations for registration and publication, pursuant to Articles 102 of the UN Charter and Article 80 of the VCLT. The Secretariat registered it on 11 June 2009 and published it in the United Nations Treaty Series. At this stage, Somalia made no objection. An assessment of the facts against the relevant provisions of the VCLT shows that the MOU indeed is a valid treaty, and the ICJ agreed Somalia was bound. We now come to the end of your lecture on the formal requirements for treaty conclusion. It is important that you know the following provisions that I listed relevant to assessing whether a person may sign a treaty on behalf of a state off by heart. The requirement to register a treaty and so forth. You have to know that. You have to know who can sign a treaty on behalf of a state. You also have to be able to put yourself in the place of an international lawyer, because we are training you to practice international law and employ the law to a factual situation in order to assess whether the formal requirements for entry into force of a treaty have been met. Thank you for your attention.